Methods of interpreting the Constitution. Verbalejes. Words given their ordinary meaning. There is no occasion for resource to other means of interpretation. It is presumed that words in construction have been carefully selected to give a definite meaning, and the framers and the people adopting it intended what they said. In the case of ambiguity, the words of the Constitution should be interpreted in accordance with the intent of the framers. Ratio leges et anima. Intent must be gathered from the letter and spirit of the document. Construction as a whole. Ut tres magis valeat quam periat. If there is repugnance, the courts must harmonize them. This is on the theory that the document was prepared and intended as a consistent whole. Every part must be given effect. The court should avoid construction which renders any provisions meaningless or inoperative, and must lean in favor of construction rather than idle or nugatory. Conflicting provisions harmonized. If there is conflict between a general and a specific provision, the special provisions must prevail, since it will be considered as limitation on the general rule. Where one provision cannot be considered an exception to another, there is conflict. The last in order of time and local position is deemed the latest expression of the will of the people. Doctrine of necessary implication. Whatever is necessary to render effective a provision, whether a grant of power of right or prohibition or a restriction, must be deemed implied or intended in the provision itself. The case of Netafan versus Comelec. Basic concepts. Declaration of principles and state policies. Article 2 in the 1987 Constitution, Declaration of Principles and State Policies, Sections 1 to 6 are binding rules which must be observed in the conduct of the government, and Sections 7 to 28 are guidelines for the orientation of the state. Section 1. The Philippines is a democratic and republican state. Sovereignty resides in the people, and all government authority emanates from them. The Philippines, under the 1987 Constitution, is not just a representative government, but also shares some aspects of direct democracy, such as, for instance, the initiative and referendum under Article 6, Section 32. Renunciation of War. Section 2. The Philippines renounces war as an instrument of national policy, adopts the generally accepted principles of international law as part of the law of the land, and adheres to the policy of peace, equality, justice, freedom, cooperation, and amity with all nations. Only refers to wars of aggression and not defensive war. Adoption of generally accepted principles of international law. Under the 1987 Constitution, international law can become part of the sphere of domestic law either by transformation or incorporation. Transformation requires that an international law can be transformed into domestic law through a constitutional mechanism such as local legislation, while incorporation, when by mere constitutional declaration, international law is deemed to have the force of domestic law. From the case of Pharmaceutical and Healthcare Association of the Philippines versus Duque III, 2007. Generally accepted principles of international law, by virtue of the incorporation clause of the Constitution, form part of the laws of the land even if they do not derive from treaty obligations. Generally accepted principles of international law are norms of general or customary international law which are binding in all states, such as 1. Renunciation of war as an instrument of national policy. 2. The principle of sovereign immunity. 3. A person's right to life, liberty, and due process. And 4. Pacta sunt servanda. International law agreements must be performed in good faith. The classical formulation in international law sees those customary rules accepted as binding result from the combination of two elements: 1. The established, widespread, and consistent practice on the part of the states, and 2. A psychological element known as opinion juris sive necessitatis, opinion as to law or necessity, from the case of Mijares versus Rañada, 2005. Civilian supremacy. Under Section 3, civilian authority is at all times supreme over the military. The armed forces of the Philippines is the protector of the people and the state. Its goal is to secure the sovereignty of the state and the integrity of the national territory. The supremacy of civilian authority over the military is implemented under the 1987 Constitution, with the President as the Commander-in-Chief of the Armed Forces of the Philippines. Civilian authority is not defeated in a joint task force between the PNP and the Marines for the enforcement of law and order in Metro Manila, as long as control is left to the PNP, from the case of IBP versus Zamora. I'm looking for more terms to define. Let's go to sovereignty. Sovereignty is the supreme and uncontrollable power inherent in the state by which the state is governed. What are the two kinds of sovereignty? 1. Legal sovereignty, and 2. Political sovereignty. Legal sovereignty is the authority which has the power to issue final commands. Political sovereignty is the power behind the legal sovereign, or the sum total of all the influences that operate upon it. Sovereignty may also be internal or external. Internal sovereignty refers to the power of the state to control its domestic or internal affairs, and external sovereignty is the power of the state to direct its relations with other states, also known as independence. State immunity. Generally, the state cannot be sued, except when the state consents to be sued. How is consent given? Express and implied. Express when it is 1. Through a general law, or 2. Through a special law. Implied is when 1. The state enter into business contracts with individuals performing proprietary functions. 2. When the state commences litigation and becomes vulnerable to counterclaim. 3. When it would be inequitable for the state to invoke immunity. And 4. The eminent domain cases. In instances of money claims, when a money judgment is given against the government, the ordinary rule for execution would not apply, for the consent of the government to be sued is only up to the point of judgment. If it does not pay, it cannot be compelled to pay by attachment or otherwise. State. A community of persons, more or less numerous, permanently occupying a definite portion of territory, independent of external control and possessing a government to which a great body of the inhabitants render habitual obedience. A politically organized sovereign community, independent of outside control, bound by ties of nationhood, legally supreme within its territory, acting through a government functioning under a regime of law. The state, as a person of international law, should possess the following qualifications: 1. A permanent population. 2. A defined territory. 3. The government. And 4. The capacity to enter into relations with other states. What is the constitutional basis for state immunity? Section 3, Article 16. The state cannot be sued without its consent. Under the jurisprudential basis for state immunity, the positivist theory and the sociological theory. Positivist theory: there can be no legal right as against the authority that makes the laws on which the right depends, also called the doctrine of royal prerogative of dishonesty. Sociological theory is: if the state is amenable to suits, all its time would be spent defending itself from suits, and this would prevent it from performing its other functions. From the case of Republic versus Villasor. What are the two theories of sovereign immunity? Absolute theory and restrictive theory. Absolute theory: a sovereign cannot, without its consent, be made a respondent in the courts of another sovereign. It derives from the principle of sovereignty equally found in sovereign equality found in Article 2, subsection 1 of the UN Charter, as well as the general accepted principles of international law. Restrictive theory: the unity of the sovereign is recognized only with regard to public acts or acts hure empire of the state, but not regard to private acts or acts hure hisiones. The Philippines follows the restrictive theory. Suits against the state. A suit against the state will not prosper if the state gives its express consent. A suit against the state will only prosper if the state gives its express consent. Consent to be sued can either be express consent through a general law and a special law. Express consent is effected only by the will of the legislature through the medium of a duly enacted statute, may be embodied either in a general law or a special law. General law authorizes any person who meets the conditions stated in the law to sue the government in accordance with the procedure in the law. Special law may come in the form of a private bill authorizing a named individual to bring a suit on a special claim. Implied consent. 1. The instances when the state takes private property for public use or purpose under eminent domain. 2. When the state enters into a business contract in iure hisiones or proprietary functions. 3. When it would be inequitable for the state to invoke its immunity. 4. When the government files a complaint, the defendant may file a counterclaim against it. When the state files a complaint, suability will result only where the government is claiming affirmative relief from the defendant. Note that when the DOTC constructed the encroaching structures and subsequently entered into FLA with Digital for their maintenance, it was carrying out a sovereign function. Therefore, these acts are iure empire that fall within the cloak of the state immunity. However, the doctrine of state immunity cannot serve as an instrument for perpetrating an injustice to a citizen. The Supreme Court, citing Ministerio versus Court of First Instance 1971, held that when the government takes any property for public use, which is conditioned upon the payment of such compensation, to be judicially ascertained, it makes manifest that it submits to the jurisdiction of a court. The department's entry into and taking of possession of the respondent's property amounted to an implied waiver of its governmental immunity from suit. The case of DOTC versus Spouses Abisina, 2016. Specific rules for bringing suits against government agencies. Suits against government agencies depends on whether the agency is incorporated or there is a special there is a separate charter or unincorporated, there is no separate personality. Incorporated is when the charter provides that the agency can sue, then suit will lie. The provision in the charter constitutes express consent. The case of SSS versus Court of Appeals, 1983. Incorporated, there must be an inquiry into the principal functions of the government. If governmental ang function, no suit without consent. If proprietary ang function, suit will lie because when the state engages in principally proprietary functions, it descends to the level of private individual and may therefore be vulnerable to suit. State may only be liable for proprietary acts, iure histones, and not for sovereign acts, iure impire. Again, the types of government agencies which can and cannot be sued. Incorporated, the function should be governmental or proprietary. The rule is that it can only be sued if the charter allows. So there has to be a separate personality or a charter that states that such government agency can sue and be sued. If unincorporated, it can be governmental or proprietary. If governmental, the rule is that the agency cannot be sued unless consent is given. If proprietary ang function sa an unincorporated government agency, then it can be sued or can sue. The mantle of the state's immunity from suit did not extend to NHA despite of its being a government-owned and controlled corporation. Under Section 6, Paragraph I of Presidential Decree number 757, which was its charter, the NHA could sue and be sued. There's no question that the NHA could sue or be sued, and thus should be held liable under the judgment rendered against it. But the universal rule remains to be that the state, although it gives its consent to be sued either by general or special law, may limit the claimant's action only up to the completion of the proceedings anterior to the stage of execution. The power of the court ends when the judgment is rendered because the government funds and property may not be seized pursuant to writs of execution or writs of garnishment to satisfy such judgments. The functions and public services of the state cannot be allowed to be paralyzed or disrupted by the diversions of public funds for their legitimate and specific objects as appropriated by law. The rule is based on the obvious considerations of public policy. The case of National Housing Authority versus Rojas, 2015. What is the rule or what are the rules for suits against public officers? So, humana ta sa government agencies. We're done with express consent, whether through a general law or the special law. So, let's go to suits against public officers. Generally, the doctrine of state immunity also applies to complaints filed against officials of the state for acts performed by them in the discharge of their duties within the scope of their authority. Exception is when the doctrine of immunity for suit will not apply and may not be invoked where the public official is being sued in his 1. Private and personal capacity as an ordinary citizen, and 2. For acts without authority or an excess of the powers vested in him, from Lansang versus CA 2000. Take note that acts done without authority are not acts of the state. What are the exceptions to prior consent rule? Jurisprudence provides these exceptions when the state or public officer may be sued without prior consent. 1. To compel the state or public officer to do an act required by law. 2. To restrain the state or public officer from enforcing an act claimed to be unconstitutional. 3. To compel the payment of damages from an already appropriated assurance fund or refund tax overpayments from a fund already available for the purpose. 4. to secure a judgment that the officer pleaded may satisfy by him without the state having to do a positive act to assist him. And 5, where the government itself has violated its own laws, from Sanders versus Veridiano, 1988. The scope of consent. Consent to be sued is not a concession of liability. Suability depends on the consent of the state to be sued, and liability on the applicable law and the established facts. The circumstance that the state is suable does not necessarily mean that it is liable, but it can never be held liable if it does not first consent to be sued. When the state does waive its sovereign immunity, it is only giving the plaintiff the chances to prove that it is liable. Estopel. Generally, the state cannot be put in estopel by the mistakes or errors of its officials or agents. Republic versus Galeno, 2017. Except when estopel may not be invoked, where they would operate to defeat the effective operation of a policy adopted to protect the public, or in those special cases where the interest of justice clearly required it. In the case of Commissioner of Internal Revenue versus San Miguel Corporation 2017, the respondent had already acquired a vested right on tax classification of its San Miguel Light as a new brand. To allow petitioner to change its position will require or will result in deficiency assessments in substantial amounts against the respondent to the latter's prejudice. Separation of powers.